It's a pleasure to meet you, Karen. I really enjoyed your book, Chasing Gideon, and I thought it was very apt that it was published on March 18th, which is the 50th anniversary of the Supreme Court's decision in Gideon versus Wainwright. And I thought we could start at the beginning. Who was Clarence Earl Gideon? Because as you point out in your book, he was a somewhat unlikely figure to have made such an impact on history.
Yeah, Clarence Earl Gideon was an itinerant chap living down in Florida, and he broke into a pool hall there, was accused of breaking into a pool hall down there, and accused of stealing some change from a jukebox, a couple of beers, a couple of bottles of wine, and arrested and brought to court there in Florida. And he approached the judge on the day of the trial and said, I'm not ready to go to trial. I want an attorney. And the judge said, well, can you afford an attorney? And he said no. And Clarence Earl Gideon said, well, I'm entitled to an attorney. The Constitution guarantees my right to an attorney. And the judge said, no, it doesn't. You have to try yourself. And the judge very kindly coaxed Gideon through the trial. But Gideon lost and, was fairly inept. I mean, the laws are very complicated. Going to court is very complicated. Selecting a jury is very complicated. And he kind of bumbled along and lost his case and was sent to prison. And from prison, he handwrote in pencil a sort of semi-literate letter to the U.S. Supreme Court saying, my right to an attorney has been violated. I deserve an attorney if I'm charged with a crime in this country. And the Supreme Court had kind of been waiting for a case like this to come along, it seemed like the timing was right. There had been several other cases that had come along that they had rejected, and they accepted his case. And in some ways it was interesting because they kind of stacked the deck in his favor by appointing him this attorney called Abe Fortas, who was this very, very high power DC lawyer at the time. And that was really to Gideon's benefit. And it was a sort of subtle signal from the U.S. Supreme Court that they were really interested in this case and were, going to help Gideon out in some ways by giving him this very powerful attorney.
I thought it was sort of ironic. It's maybe the first and almost the last time that the indigent defendant had really an advantage over the state of Florida, because as you wrote in the book, the lawyer who was representing the state of Florida, was it Bruce Jacob, was very young, inexperienced, had never argued a case before the Supreme Court, and wasn't even working at the state attorney general's office for the latter part of preparing for the case, which I gather he was doing on nights and weekends.
Yeah, he was really, flying by the seat of his pants, and in fact, had to get qualified to argue before the Supreme Court only a day or two before he appeared before them. And he, in his memoirs, has written, I didn't even think to bring a pencil up with me when he stood before the judges to make his oral arguments, to jot down their questions or any of that, and was extremely flustered. And he's been very frank and forthright about that in the years since, and has since become actually an outspoken advocate for public defenders and public defense. But at the time, it was a very mismatched case, and Gideon did end up winning his case in 1963, and that really was a radical shift for the judicial system, in that suddenly all across the country, anyone accused of a crime who couldn't afford an attorney was entitled to one.
Did the justices seem to give much consideration to the cost for state and local governments of giving free lawyers to poor people accused of crimes? How much did that seem to weigh into their calculations?
That was definitely part of what they anticipated as the sort of pushback from people. They themselves, it sounds like, debated it and worried about it, but ultimately decided that this was a constitutional right, and that the states or counties or cities were going to have to find a way to absorb this cost. So they basically, gave this mandate, but they didn't fund it. So they said, you must do this, but they did not say how states would go about funding this. And what that meant was that every state in the country now has sort of a different mishmash set of systems, and sometimes they're county funded, sometimes cities have their own public defender's office. It's a very complicated house of cards in many ways, because some places it works, some places it doesn't. You may have a very good public defender if you're in the city of New York, but if you drive 2 hours north and are in upstate New York, you may have work with a lousy system and have a far greater chance of being convicted of a crime. So it's really never been worked out very well.
Yeah. I was struck that you quoted, I guess during oral arguments, Gideon's lawyer, Abe Fortas. He sounded almost cavalier about it, saying, I see no real difficulty with funding it. And one thing you point out is that the criminal justice landscape is very different now than it was when Gideon was decided. I think at the time there were, about 200,000 people in prison, and now there are about 2.3 million people. So what has happened in the intervening 50 years?
Well, what has happened is there's just been this flood of arrests and clients coming through the system thanks to the war on drugs, which has sent lots of people into the courts, mandatory minimum sentencing, pretrial detention, and underfunded public defender's offices, which mean that people are languishing in jail for much longer. So all of that has created this tremendous crisis in the courts. And as you say, it's jumped, even in the last 30 years from 300,000 to over 2 million today, due to those changes in what we're arresting people for and how we're arresting them and how long we're holding them. So it's created this flood of people, and the numbers of people needing public defenders has just skyrocketed since the Gideon decision was handed down.
Right, and that's, of course, one of the main themes in your book is the crushing caseloads that public defenders face. You wrote, there are all kinds of problems with the patchwork system of indigent defense in the United States, but by far the most critical is the crushing caseloads that, in essence, violate a defendant's Sixth Amendment right to counsel by providing it, in many cases, in name only. And in the first chapter of your book, you really dig into this by telling the story of two cases, one involving an 18-year-old young man who was charged with vehicular manslaughter, and another, a 12-year-old boy who was charged with molesting another child. And I thought we could talk about this, maybe about the case involving the 18-year-old first. What happened to him?
This is a story about a young man named Sean Replogle who was arrested when he was 18 years old. He had just turned 18, just got his first car, a used car, and he was driving it. He was actually on the way to cash his paycheck to go pay for car insurance, and he was in a car accident. And he was not at fault. He had the right of way, and an elderly gentleman and his family pulled in front of Sean, and he hit the car. And the elderly gentleman was taken to the hospital, and about 9 days later he died. And Sean Replogle was charged with vehicular manslaughter. And he had a public defender in Spokane, Washington, a woman named Carol D. Hunnicky, who really went to bat despite her crushing caseload. So she was carrying at that point about 101 cases compared to the prosecutor who was working opposite her, who had 36 cases. So she was pushed to take this case to trial before she was ready. She'd done several trials in the last 2 months, and she said to the judge, I need a little more time. And the judge said, no, you've got to go ahead. And, this was like a Friday. She had to go to court on Monday. And she decided to refuse and take a stand and say that would be ineffective assistance of counsel if I were to go to court and represent him on Monday when I'm not prepared for a trial. And due to the crunch of money in their office, and there was limited investigators, limited ability to call in experts, etc., she really was like, I need more time. The judge threatened to hold her in contempt of court. Ultimately, she was given a few more weeks to prepare for the trial, which turned out to be a good thing, because what she discovered when she hired the experts was that the elderly man who had been hospitalized had been operated on for an hernia, which was a pre-existing condition.